Hello everybody, this is FWS91 here, and today we're going to be talking about the background of the 14th Amendment and why this matters. Now let us begin. As you can see here, I brought up an article, and it's about a fun fact that many people don't know, but that the 14th Amendment was ratified unconstitutionally, and that it really has no legal value because of this, at least constitutionally. And this is a good article briefly explaining the history of the 14th Amendment, and this was published in the U.S. News and World Report on September 27th, 1957. Okay, so this isn't some hillbilly writing about it on here, okay? Now, this isn't really taught in our schools or in our colleges for the most part, and it's something most people don't know. As we can see here, because of the undisputed evidence officially recorded by the journals of historians, unanimous historians, and records in Congress, both in national and state, we know that outside of 6 states of the South, or outside the South, 6 states, New Jersey, Ohio, Kentucky, California, Delaware, and Maryland, failed to ratify the proposed amendment. And then that in the South, 10 states, Texas, Arkansas, Virginia, North Carolina, South Carolina, Georgia, Alabama, Florida, Mississippi, and Louisiana, by formal action of their state legislatures, rejected it under the normal processes of civil law. And this was occurring in 1867 and 1868. Let's keep going. A total of 16 legislators out of 37 failed legally to ratify the 14th Amendment. Congress, which had deprived the southern states of their seats in the Senate, did not lawfully pass a resolution of submission in the first instance. The southern states which had rejected the amendment were coerced by federal statute or law passed in 1867 that took away the right to vote or hold office from all citizens who had served in the Confederate Army. Military governors were appointed by the federal government and instructed to prepare the roll of voters. All this happened in spite of the presidential proclamation by Andrew Johnson of amnesty previously issued by him. New legislators were thereupon chosen and forced to ratify under penalty of continual exile from the Union. In Louisiana, a general sent down from the North presided over the state legislature. So let me just pause right here. So right here we have this. It's after the Civil War. Johnson's president because Lincoln got assassinated. And Lincoln, during his whole war, he was saying, that a house divided against itself cannot stand. And he said, that his argument was they can't constitutionally secede. You can't. The southern states can't. And that he didn't recognize them as a nation, the Confederacy. Although, fun fact is that the Vatican either did or at least considered it during the war. And France and Britain were looking at it. I mean, France was possibly going to, and they would have come and helped us if, or if they were interested at least. After Johnson late in the war said, okay, if we... And they made a bargain with him saying, look, we'll help you, or at least we'll consider it if you can pass a law banning slavery in your territory, Okay, and so that's what they're going to do. That was going to happen, but... So, I mean, not only that, but under national law during the Civil War. Brief fact. National law, not just in America, but world laws of war, was that you do not block a territory's port, or if any area, you don't blockade it with warships unless you're in war, unless you recognize them as another nation, so to speak. I didn't express it good enough, but I'll put a description below to help give more information on it. But I mean, you did not blockade another area's ports unless you want to go to war, which would be a declaration of war if you're doing that, and it recognizes it as a nation, and which Lincoln didn't recognize. And now you have it here, where the Congress and the Senate are saying, you Southerners, you're not going to get your representatives, you're not going to get your senators coming up in the national government until you ratify this 14th Amendment. And they made an 1867 law passing it, saying, well, they passed it and went to President Johnson, and he vetoed it. And as we're going to notice later, they're going to override it. And he said it was unconstitutional. There's nothing in the Constitution that says that you can force states to sign an amendment and ratify it. And if they're not states, if they're not part of the Union, doesn't a state, recognized as a state, supposed to ratify it? So let's keep going. I mean, let's just let it speak for itself. Right here, he said, inseparable, indivisible. Lincoln said that. After his death, when the war was over, the ratification by the Southern states of the 13th Amendment abolishing slavery had been accepted as legal. But Congress in 1867 law imposed the specific conditions under which Southern states would be entitled to representation in Congress. Congress, in passing the 1867 law, that declared the Southern states could not have their seats in either Senate or House in the next session unless they ratified the 14th Amendment. Took an unprecedented step. No such right to compel a state by an act of Congress to ratify a constitutional amendment is to be found anywhere in the Constitution, nor has this procedure ever been sanctioned by the Supreme Court of the United States. President Andrew Johnson publicly denounced this law as unconstitutional, but it was passed over his veto, as I just mentioned to you. Secretary of State Seward was on the spot in July 1868 when the various ratifications of a spurious nature were placed before him. The legislators of Ohio and New Jersey had notified him that they rescinded their earlier action of ratification. He said in his official proclamation that he was not authorized as Secretary of State to determine and decide doubtful questions as to the authenticity of the organization of state legislators, or as to the power of any state legislator to recall a previous act or resolution of ratification. He added that the amendment was valid if the resolutions of the legislators of Ohio and New Jersey ratifying aforesaid amendment are to be deemed as remaining of full force and effect, notwithstanding the subsequent resolutions of the legislature of these states. This was a very big if. It will be noted that the real issue, therefore, is not whether the forced ratification by the 10 southern states was lawful, but whether the withdrawal by the legislators of Ohio and New Jersey, 2 northern states, was legal. The right of the state, by action of its legislator, to change its mind at any time before the final proclamations of ratification is issued by the Secretary of State as has been confirmed in connection with other constitutional amendments. So what's funny is there's a double standard here is what he's basically stating, or what he's really worried about. He's worried about these 2 northern states rescinding, overruling, and changing their mind by formal declaration that they approved the amendment, and they say, nope, we don't. Nope, JK, we weren't really thinking there. Now we've considered, no, we don't like it. And so that's what we have here. Number 10. The Oregon legislature in October 1868, 3 months after the Secretary's proclamation was issued, passed a rescinding resolution which argued that the 14th Amendment has been ratified by 3/4 of the states, and that the ratifications in the southern states were usurpations, unconstitutional, revolutionary, and void, and that until such ratification is complete, any state that has a right to withdraw its assent to any proposed amendment. What do historians say about this? The Encyclopedia of Americana states Reconstruction added humiliation to suffering, 8 years of crime, fraud, and corruption followed. And it was state legislators composed of, it says right here, I'm not approving this term, but I'm reading a quote here, as you can plainly see, of blacks, carpetbaggers, scalawags, who obeyed the orders of the generals and ratified the amendment. W.E. Woodward, in his famous work A New American History, published in 1936, says, to get a clear idea of the succession of events, let us review President Andrew Johnson's actions in respect to the ex-Confederate states. 1865, he issued a proclamation of amnesty to former rebels. Then he established provisional government in all the southern states. They were instructed to call constitutional conventions. They did. New state governments were elected. White men only had the suffrage. The 15th Amendment establishing equal voting rights had not yet been passed. Senators and representatives were chosen, but when they appeared at the opening of Congress, they were refused admission. The state governments, however, continued to function during 1866. Now we're in 1867. In the early days of that year, Stevens brought in, as chairman of the House Reconstruction Committee, a bill that proposes to sweep all the southern state governments into the wastebasket. The South was to be put under military rule. The bill passed. It was vetoed by Johnson and passed over against his veto. Right here, he denied it's unconstitutional because you can't put military rule under the states, forcing them to sign the 14th Amendment. There's no such thing in the Constitution that says that. And let me give a brief example here about this. Kevin Gutzman, who's a constitutional scholar, really smart, brilliant man, one of the authorities on constitutional law, had this to say. He gave an example of what happened here right now. Alright. He said, let's say, for example, Iran comes in and invades the United States and puts all the states under compulsion. It says, we will not let you be your own states again in your own government until you ratify, all you states, an amendment having full legalization and jurisdiction of Sharia law in all civil affairs. And let's say they ratified it. Would that still be an amendment? Would we follow that if we got rid of the yokes of Iran oppression? No. It wouldn't count because we're under compulsion. We didn't do it on our own free will. It's the same thing here. In challenging its constitutionality, President Andrew Johnson said in his veto message, I submit to Congress whether this measure is not in its whole character, scope, and object, without precedent, without authority, and palpable conflict with the plainest provisions of the Constitution, and utterly destructive of those great principles of liberty and humanity for which our ancestors on both sides of the Atlantic have shed so much blood and expended to so much treasure. Many have applauded Johnson's words, many historians. Samuel Eliot Morison and Henry Steele Commander, known as the Liberals, wrote in their book The Growth of American Republic. Johnson returned the bill with a scorching message arguing the unconstitutionality of the whole thing, and most impartial students have agreed with his reasoning. We just have a whole bunch of it right here. Here's what's funny. Here's a, constitutional history of the United States. Andrew McLaughlin said, can a state which is not a state and not recognized as such by Congress perform the supreme duty of ratifying an amendment to the fundamental law? Or does a state, by congressional thinking, cease to be a state for some purposes but not for others? This is the tragic history of the so-called 14th Amendment, a record that is a disgrace of free government and a government of law. Isn't the use of military force to override local government what we deplored in Hungary? It is never too late to correct injustice. The people of America should have an opportunity to pass an amendment to the Constitution that sets forth both the right of the federal government to control education and regulate attendance at public schools either with federal power alone or concurrently with the states. That's the honest way, the just way to deal with the problem of segregation or integration in schools. Until such an amendment is adopted, the 14th Amendment should not be considered as null and void. Should be considered as null and void. There's only one supreme tribunal. It is the people themselves. Their sovereign will is expressed through the procedures set forth in the Constitution itself. Now, this is probably in response to Plessy versus Ferguson, as it's set up here, I believe. Desegregation public. Okay, I'm not against desegregation. Okay, I'm not against it. I'm for it 100%. My main point is talking about this, the history of the 14th Amendment. This is what they use this in argument for that, but I'm not using it for that. No. I'm not racist or anything, or sexist. I don't believe segregation should be allowed, But I'm just talking about the history of this. Now, some other things it was used for, yes. But ultimately, we'll just talk about that another day. But that's the background to the 14th Amendment. In the next video we're going to be talking about some of these Supreme Court decisions with using the 14th Amendment, 2 clauses that are very popular. Okay, so until then, I will see y'all later, and God bless, and have a nice day.